this is just a little longer battle than we anticipated, but the battle's not over, and the war's not over, and the fight will continue for press freedom for our clients. The idea that the legislature is a non-public forum is just flies in the face of 50 years of tradition. Yeah, as we argued that day in our briefing, it's a limited public forum, and as such, members of the press are entitled to robust protection in the rights in the areas that they have traditionally been allowed to be in. I thought it was a little odd that the court acknowledged that there were problems with how the due process that was allowed, the process that the legislature used in terms of how it approved or denied the press passes, the fact that it could take days for them to approve a day pass. In fact, 3 of my clients didn't find out until 2 or 3 days later that the day that they had applied for, that they weren't eligible to have it, and they didn't have the facts necessary to know and to be able to contest those. The court said, yeah, that's problematic, but ultimately kind of brushed that aside, in my opinion. The court said that there wasn't enough evidence that the reason that my clients were excluded, Brandy and Ari, was based on their political participation. That was in the affidavit from the state defendants, where they said, we know you're going to be speaking at a rally, and it certainly formulated the basis, and that's content-based discrimination, which under the cases we cited cannot be the reason that you don't allow a member of the press to have access.